morning and welcome to the Court of Appeals. I want to take just a few moments before we get started and make sure we're all on the same page about procedure and a few other matters. I realize that I'm dealing primarily with experienced practitioners, but always feel the need to run over the ground rules anyway. Each side gets 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, please do that by after you come to the podium and introducing yourself. Request that time. You may reserve up to 5 minutes of rebuttal time. Obviously, the appellee gets no rebuttal time. In order to aid the attorneys, we have a monitor on the podium. The monitor, once you begin speaking, has 3 lights on it. The green light will come on, which means you've got plenty of time. When the yellow light comes on, it means you're running out of time. And when the red light comes on, you are out of time. So we ask that you please respect those time constraints. Your panel this morning consists of Judge Kenny Armstrong from Memphis, Judge Carmen McGee from Savannah, and I'm Steve Stafford from Dyersburg. One thing that I do want to caution everyone about, I'm not sure caution should be the right word, but it at least is a heads up, and that's this. These arguments are being live streamed, which means essentially, once you say it, it's out there for the world. So please think about what you're saying before you say anything, because you don't get a do-over on this one. Anything we need to take up before you call the first case, Ms. Ashley? All right, you may call the first case, please.
Abigail, Lynn, Sevigny versus Warren, Maxwell, Sevigny.
We will hear from the appellant.
Good morning, Your Honors, and may it please the Court. My name is Sean Aiello of the Williamson County Bar, here on behalf of the appellant, Abigail Sevigny. Before I begin, I'm reserving 5 minutes for rebuttal.
5 minutes? All right, sir. You may proceed.
On appeal, Ms. Sevigny asked this Court for 3 main grounds for relief. 1, to reverse the trial court's final order finding Ms. Sevigny in criminal contempt of counts 1, 5, 10, 12, 13, 17, and 28, and the associated sentence of 29 days in jail suspended for those findings. We also ask that the court reverse the trial court's order awarding Mr. Sevigny his attorney's fees under TCA 36-5-103C, as well as the party's NDA. And then finally, we seek an award for Ms. Sevigny of her reasonable attorney's fees incurred in defense of the claim for criminal contempt, as well as the pursuit of this particular appeal. Your Honors, this is an expansive appeal that would require the court to examine the enforceability of the state promulgated and required preamble language contained in the Uniform Parental Plan forms issued by the AOC, the effect of the incorporation writ large of the Bill of Parental Rights contained in TCA 36-6-101, also incorporated into the state mandated parenting plans, and then finally the applicability of the Tennessee Criminal Sentencing Reform Act to sentencing on criminal contempt convictions. The appellant respectfully asserts that the trial court erred in finding Ms. Sevigny in criminal contempt of those stated counts and sentencing her to 29 days in jail associated with those findings, now seeking a review and reversal of the same. Following the filing of a 29-count petition for criminal contempt against Ms. Sevigny, the appellant lodged a memorandum of law detailing her legal position and constitutional offenses raised, providing Rule 24 notice to the Attorney General of its potential interest in this proceeding. The state declined to intervene, stating that, yes, even though this might be state-related language, it was not the language of the preamble did not derive from any statute or rule discernible by the state, and that her concern with the statutory language of the Bill of Rights was really one of application as opposed to constitutionality writ large, so they declined to intervene at that time. The court ultimately had a final hearing and a sentencing, finding that the preamble of the Permanent Parenting Plan, as well as the Bill of Rights as incorporated, was constitutional, and that the language therein was unambiguous, a lawful order, and clear as to its directives. And so as a result of the findings of the court, found Ms. Sevigny in violation and contempt of 7 counts of the 29 pled counts.
Did your client testify?
No, Your Honor. The trial courts are mandated to use the AOC court parenting plan forms in all divorce or other related custody actions. TCA 364404 D tasked the AOC with drafting a parenting plan form and dictates that the same shall be used consistently across jurisdictions. Neither the trial court nor parties have discretion to deviate from substantially altering these mandated parenting plan forms, which include the preamble and incorporation of the Bill of Rights. When presented with these plans, the AOC has a FAQ section for judges answering the question of whether there's a standard parenting plan form used in the states, and the response is yes, there is a mandated form, directing them to the AOC website for use of the form in this case. The required prefatory and statutory language becomes part of all legal orders dealing with custody in this state, and are then therefore subject to the same scrutiny as any other order would under the criminal contempt element analysis. The trial court has no discretion as to whether to remove or otherwise modify the state-drafted provisions from its parenting plan order, and must therefore enter a plan of compliance with the applicable statute. Counts 1 and 5 of the criminal contempt brought against Ms. Sevigny rely upon the preamble of the Bill of Rights, and specifically the portion of that preamble that states that, quote, they will not speak badly of each other or the members of the family of the other parent. This appears intended to provide really aspirational guidance for interactions between parents after divorce, but the specific language cannot be tied to a statutory origin or author beyond the knowledge that the AOC developed it in connection with a statutory obligation, wherein it states that it's to be drafted with conjunction of various committees and, quote, other knowledgeable persons. There is a distinct lack of case law examining the enforceability of the preambles. Upon review, counsel was able to identify really 2 unreported cases that were from the mid-2000s. One, Dellinger v. Dellinger, which referenced this provision as an aspirational provision, and then another, Bourne v. Russo's, that upheld a contempt based on the preamble, but did not have any analysis as to whether it constituted a clear, specific, and unambiguous order, because it appears neither party raised that issue either at trial or on appeal.
In this specific instance, though, wasn't it they won't speak badly about each other to the child?
So the court relied on kind of a combination of the preamble with that they will not speak badly of each other, and then also the Bill of Rights that says there is a right to be free of derogatory comments. And the court seemingly took those 2 together to determine that there was a conjoined violation of both of those provisions in 2 instances in counts 1 and 5. Importantly, in looking at not only the bill.
Why don't you answer my question?
Sure. Yes, the court did determine that the language that was used was in front of the minor child.
Okay, that's what the court found your client guilty of, was derogatory comments made to the child about the other spouse or other parent, excuse me.
Yes.
Okay, all right.
And specifically.
So what specifically are you saying is unconstitutional here?
So we're not necessarily asserting that it's unconstitutional, either the preamble or the Bill of Rights. What we're asserting is that the application in a criminal contempt proceeding, when tasked with having a clear and unambiguous order, whether the language as applied creates an issue for notice standard for the parties.
Are you saying your client wasn't aware that she couldn't speak badly about the other parent to the child?
Not so much that she couldn't speak badly, but as far as what that definition of badly is in the context of the aspirational preamble.
Doesn't the court examine that when there's testimony that your client said this, whatever this may be, to the child? And then it can be tested on cross-examination about whether that would be found to be derogatory or inappropriate.
It could, Your Honor. The problem is there's not a uniform standard for the courts to apply across jurisdictions on what either that term badly means or what an unwarranted derogatory comment is. And I think also it's important.
What if the trial court simply said it was offensive or
court,
inappropriate?
The court did in this case. But the question of whether the Bill of Rights itself can form a foundational basis for a contempt is one of those that needs to be examined as well. Because in the Bill of Rights, as it pertains to the derogatory statements, it states that their parties have a right to be free from derogatory statements, but does not place an obligation of affirmative or restraining action on the other parent. In looking at the Bill of Rights in total, there are two specific words that are used throughout, and seemingly not interchangeably. One is a right, and the other is a shall mandated directive. For example, under the telephone, right to unimpeded telephone calls, there is a right set forth of a right to unimpeded telephone calls, and then it says the other party shall provide X, Y, Z to allow this phone call to take place. The other example would be in the case of travel itineraries. There's a right to receive a travel itinerary with certain things provided, and then it says the party shall provide the mode of transportation, the dates, and the location. So in the context...
So are you saying, is it your argument that if a parenting plan simply states that both parents are awarded those rights that are stated in the Parents' Bill of Rights, that that is not clear as to what is either allowed or prohibited by either party? That's not enough for the court just to say both parents are awarded those rights. The parenting plan would have to separate and apart set out in the, I guess, other provisions section. Number one, neither parent will speak in derogatory manner of the other. Number two, both parents will notify the other parent within 48 hours and actually set out everything that's a provision in that Bill of Rights. That just incorporating that Bill of Rights or referencing that Bill of Rights is not enough to make that an order of the court?
No, Your Honor. With those provisions of the Bill of Rights that do have mandated directives such as shall provide, that becomes an incorporated order of the court. But when it simply espouses a right, so a right to access to information or a right to receive certain things or right to be free of certain things, that will give the court leeway to then put in specific provisions to enforce those rights. But stating forth those rights themselves does not in and of itself create a lawful order that could be potentially held in contempt thereof.
Thank you.
Thank you.
Good morning. If it please the court, I'm Helen Rogers of the Davidson and Williamson County Bars, and it's been my pleasure to represent Mr. Sevigny in this matter. We're really here because Mrs. Sevigny cannot be wrong and cannot accept the fact that the court found her guilty on these 7 counts. We look at the Supreme Court's case of Convoluca, and first of all, was there a lawful order? Yes, there was a parenting plan that had the same language that every other parenting plan in this state has. Ms. Sevigny is not special or exempt from being able to read that parenting plan, and the language to not speak badly to each other is clear, specific, unambiguous, telling in front of the child, and there was a recording the judge got to hear when she's arguing with what time the child's supposed to be returned, and the father is trying to tell her the correct time, and she's arguing and says, if you don't bring the child back by 6 p.m., I'm going to call the police. That is not just a violation of the preamble, but it's a violation of the parenting right to be free from unwarranted derogatory comments.
How is that a derogatory comment when she says, based on my reading of the parenting plan, the child should be returned at 6 o'clock, and if you don't do that, I'm gonna call the police?
Well, it's,
Derogatory has to do with an expression of some low opinion of the other party. How is that an expression of a low opinion of the other party?
it's an expression to the child that your father is violating the law. And by the way, the father was right in that situation, but violating the law, and I'm gonna call the
I don't believe
police.
the court found that the father was right about what the return time was on that particular holiday. In fact, the court says as much
Okay.
during the course of the hearing, but go right ahead.
Okay, well, my memory then is not perfect on that issue, but you have a right to be free of derogatory comments, and calling the police is an indication that dad has done something wrong. The other derogatory comment was on a FaceTime call, basically telling the father that he was a thief, because he and the child.
I've read the transcript.
Yes, sir.
She never called the father a thief. In fact, she didn't have a conversation with the father. The conversation was with the child.
On the FaceTime call.
The testimony at the trial,
Yes, sir.
there was no conversation with the father. It was a statement to the child about what he couldn't do.
But
How is that a derogatory comment?
Well,
How is that speaking badly of the father?
it appeared to me when I was hearing the testimony and the judge's ruling on that is that it cast the father as having done something wrong by taking the light.
No, the conversation was, the kid said, since this boat is abandoned, let's go and take all the treasures off it.
Right.
And the mother says, no, that wouldn't be right, that would be stealing.
But she was excited. I think the point was he was excited about this thing that his father, and he had worked up and he had turned the light so it would turn on the light. And that was exciting to the child. But those aren't the only contempts either.
Talk us about the other contempts.
Okay, so count 12 was, there was a parent orientation for kindergarten. And this is, again, the standard parental rights. You're supposed to notify the other parent of things that are going to occur in the normal, and I don't have the exact language.
Is that what the plan says, that you're supposed to notify them of things going on in school? Or
Yes,
does it
sir.
say that you have an obligation to notify them of things that you signed the child up for? Because that's the way I read it. If she signs a kid up for something, then she has an obligation to notify the other parent within 48 hours of that event.
Well, this was if you'll recall, and obviously you're very familiar with the record, if you'll recall that it was almost like a gotcha kind of action that the mother took. She texted right after the orientation to the father about this orientation. And it was an hour after it had occurred. And so I think the court saw that as somewhat mean-spirited.
But how does it violate the parenting plan, given the language that says the obligation of one parent to notify the other is only when they sign the child up for that activity? This is not an activity that the mother signed the child up for.
I haven't ever seen that kind of interpretation. I believe the language is the right to know about activities, but I don't have the parental rights in front of me, and I should.
Right. The father does have a right to notification, but that's as between the father and the school,
Sure.
which your client failed to do. He failed to make the necessary arrangements with the school so that the school could notify him of events. Are you saying because he failed to do that, the mother is obligated to notify him of everything?
I think the mother enrolled the child at the kindergarten to start with. It was where she selected and where she put the child. So I don't think it's necessarily, if mother had signed up, it makes common sense. The father should have been told, this is what you have to do at the school I put the child in, just as if you sign him up for soccer. And the soccer league says, here's our email address to get the schedule. I would expect she needs to tell the father that information.
And wasn't the father given the information so that he could sign up with the school, and he failed to do it for months and months?
I don't recall that part of the transcript, if I may have missed that.
It's in the transcript.
Count 17 was when she didn't give him the return itinerary when she took the child to Washington State. That's a requirement under the standard parenting plans. Counts 10 and 20.
Let me ask you about the trip.
Okay.
Does the parenting plan define what an itinerary is?
Well, sir, I was here at the Court of Appeals in the O'Rourke case on that very issue, and after that, the language in the standard parental rights was changed somewhat. And I think it now says mode of transportation, location, and how to contact the other person.
And was the father provided with that?
No, sir, he was not.
Am I missing something? Wasn't there a hearing 1 month before this trip where the mother testified, also provided an exhibit that indicated they were flying out on a certain day and flying back in on a certain day, and the trial court entered an order allowing that trip, set the dates? Isn't that right?
My client didn't know where the child was or how to contact the child.
The order said they were going to be in Seattle, Washington.
Yes, sir, that
Did
she
it
was
not
allowed to
say
take
that?
that trip. It did.
So what was missing?
Where in Seattle, Washington they were going to be and what flights they were on.
Is there anything in the plan that says that you've got to include the flight number or the hotel?
Well, I think some of that may be common sense. I think every parent ought to know if a plane crashes whether or not their child was on that plane. And if the Seattle, Washington is a big place of where the child is going to be.
Does the order provide for that?
I think that that's what the standard parental right requires. That's certainly what I tell my clients they're obligated to do.
But does the order provide that that's got to be provided by the other parent?
I would disagree with your interpretation of what the order requires.
No, I mean, you know what the parenting plan says.
Sure.
Does it say that you've got to provide a flight number? Does it say that you've got to provide a hotel
I think it says
accommodation?
mode of transportation. I think is what it
And the order
says.
and the exhibit at the hearing a month in advance of this trip indicated that they were flying to Seattle
Yes, sir.
on the 3rd and returning by flight on the 5th. Isn't that right?
Yes, sir, it does. But
Okay.
I don't think that completely satisfies the standard parental rights. Counts 10 and 28 provide, the party's order said that they would pick up and deliver the child at the parent's home or a mutually agreed upon in writing location. There was no mutually agreed upon writing location on July 24th of 21, and mother sent father a text, "You're not allowed here," meaning her home. And he was not able to pick up the child. Again, on January the 6th of 22, she said, "Don't pull into the driveway or come to my door again." Now, at trial, she defended that by saying he could have parked in the street. I don't think when you get a text from the other parent saying, "Don't pull into the driveway or come to my door again," that you would feel like you're welcomed, especially when there was a threat to call the police over an exchange time. So father missed those 2 times. The court found her guilty of those contempts. Then,
I'm sorry, so if we look at the transcript, there will be a finding that there was no exchange at all on the dates that you just mentioned.
no, I think what happened was he ended up agreeing to meet her at some parking lot, which is not what he had to do, or, I mean, again, what message does it send to this child that these parents can't even be at the same home with each other? We have a young child that is subject to this constant fighting. And then count 13, so that was counts 10 and 28. Count 13 was the language in their parenting plan says that he can either pick the child up after school on Thursday, or if no school at 3 p.m. Did I say that? Yes. So on that Thursday, school let out at 10 in the morning. Ms. Sevigny would not allow the father to pick the child up from school at 10 a.m. and insisted he could only get the child at 3 p.m. Again, he missed that parenting time. And, you know, in divorce cases, parenting time is really important to mothers and fathers. It's all the time they have. This father has less time than the mother. So, you know, missing 5 hours of parenting time is significant to him. And the language of the parenting plan is really pretty clear and pretty unambiguous.
What did the trial court say about the language of the parenting plan with regard to the early pickup for 3 p.m.? Did the trial court say that that was specific enough?
Well, it was specific enough for him to find her guilty beyond a reasonable doubt. Yes, sir.
Were you there for the hearing?
I was. I tried this case.
What did he say initially about whether that should have been drafted differently?
Well, I think what he said was I could have done a better job on how it was drafted. And I'm responsible for drafting the language, so yes, I could have probably made it more perfect, but it won't matter. Ms. Sevigny will find a way to drive through this.
Okay.
The two cases that my adversary relies on, the Killinger case, doesn't really stand for the proposition I think he cites it for. What it says is, considering these facts in light of the order at issue, the aspirational preamble to the parenting plan, the evidence of the record falls well below and beyond a reasonable doubt that mother's actions at the soccer game constituted a willful violation of the preamble or any other order. So the Kindlinger case did not find that the preamble wasn't valid. It just found that in that case there had been a violation of it. The Bourne versus Russo's case is a case that I also tried and did the appeals on, and the Court of Appeals did uphold the preamble language as a violation of that order. So you had 29 counts. The court found her guilty of 7. We were the prevailing party. I think you prevail if you find your client guilty of criminal contempt, and we were awarded attorney's fees based on a pro rata formula that the judge imposed.
Let me ask you, how is Bourne analogous to our case?
Only analogous in the standard that a preamble was enforced, that the language of the preamble.
But in the Bourne case, the father referred to the mother as a liar and a tax cheat. We don't have any of that in this case, do we?
No, sir, we don't have that. We just have an implication that you're a thief and that I'm going to call the police on the father of my son.
Okay.
Thank you.
Thank you.
Your Honors, as it pertains to the argument about the preamble language and the Bill of Rights, just to be clear, Ms. Sevigny is not arguing that either of those provisions are unconstitutional or should be stricken in their entirety. What she's arguing is, as applied in the strict analysis of criminal contempt, under the threat of incarceration, that a party be put on adequate notice of what specific conduct will be in violation of direct orders of either affirmative action or restrained action that could result in her violations of the same. When we're talking about the...
So what is it you say is lacking?
Specificity, Your Honor, and frankly, the overbroadness of the preamble itself. The sentence that they will not speak badly of each other or the members of the family of the other parent is not restrictive to in the presence of the minor child.
You keep leaving out badly of each other to the child.
And that's not contained in the preamble, but that's contained later on in the Bill of Rights.
But that's what the trial court found, right?
That's correct. The court,
So doesn't that take it out of the issue that you're attempting to raise? The trial court was more specific in its finding than the preamble requires.
that's correct. I think the court cited both of them, but it did use the language unwarranted derogatory statement in its final sentence about the finding of the contempt for those specific points. There was some argument in the responsive brief that these two provisions need to be taken together and read as a whole. But one is a Bill of Rights statute that's separate and wholly apart from this preamble, which I believe means well in its intended drafting, but when it's used under the specific concern of criminal contempt, the parties have to be put on notice of what specific conduct on any provision could result in.
Tell us about her conduct. What conduct violates either one of those?
So there were two specific phrases the court identified. Under count one, the court identified the phrase, "We need to get this figured out. It's Monday at 6 p.m. or I'm going to call the police." The court determined that was the derogatory statement made in the presence of the minor child.
Is that derogatory in your opinion?
Not in my opinion, Your Honor, but in looking towards a statutory definition or anything to that effect, I think the court was unable to lay its finger on any specific guidance on that issue. But Ms. Sevigny's position is that was not a derogatory statement. And the second count 5, it was a sentence, no, that's stealing, and a statement made to the child that the court determined to be a unwarranted derogatory statement or speaking badly about the other parent. And Ms. Sevigny's position on those two as well is that that was not a derogatory statement made about father. The other significant issue we have, Your Honor, of whatever counts remain as a result of the criminal contempt findings, the court sentenced Ms. Sevigny on a seemingly arbitrary manner without consideration of the Sentencing Reform Act. For example, the sum of the analysis of what punishment was appropriate for each count was count 1, 1 day, count 2, 2 days, count 3, 3 days, until we get to count 7, which deals with the sending of a text message of "don't come to my door" or "park in my driveway," which the court then sentenced mother to 7 days in jail for sending that message as a purported violation of or unilateral change of the transportation arrangement. The Tennessee Supreme Court has been pretty direct in In re Sneed that the courts need to apply the Tennessee Sentencing Reform Act in imposing sentences for criminal contempt. And while there is leave to do consecutive sentencing, such as the court did in this case, it does direct the court to have some independent analysis of not only the independent claims, but other factors that the court should consider, including prior contempt actions, violations, things of that nature, none of which was applied as to the ultimate charges in this case.
Let me ask you about the text saying "don't come to my driveway." Had they ever exchanged the children at their home?
It didn't appear so. The testimony at trial was that the parties had really never exchanged to the house since entry of the parenting plan, and that father simply acquiesced to different locations to, quote, avoid a fight. So there was no testimony of deprived parenting time or that there was an issue of coming to the house for exchanges. After this trial took place, the court made some significant modifications to the parenting plan to address many of these issues and clarify some points, including transportation drop-offs. But as is written in the plan itself, the conduct that has been described to be violative of the parenting plan simply does not meet the applicable criminal contempt standards.
So are you saying the trial court gave no reasoning in its sentencing?
I would say it would be very limited sentencing. The sentence that the court used right before issuing its order, it simply stated that he wasn't sure how to import the importance of these actions other than to proceed as he was going to proceed. There's about maybe one paragraph of discussion about the basis for sentencing.
Or what would that encompass?
So the specific language the court used, let's see. It said, "We have 7 counts of contempt. My understanding of the Court of Appeals rulings on range of punishment is that the court is to use the least draconian method of resolving the problem, and the difficulty is that I don't know how much of an impact I need to make on Ms. Sevigny in order to make its impact. And then it says, but the court, in regards to count 1, is sentencing her to 2 days in jail, and then proceeds on through there. And that's the sum of the analysis.
Okay, so, obviously, the sentencing is an abuse of discretion.
That would be correct, Your Honor.
What you're saying is that we don't have anything to ascertain how the court exercises discretion.
That's correct. The only other sentence the court says about it, it says what the court is trying to do is for each offense, the court is making the punishment more and more and more. And that was it.
Progressive.
Yeah.
Thank
Your
you.
Honors.
Thank you, counsel. We appreciate your argument and your briefing. We will take this matter under advisement and attempt to render an opinion at the earliest possible time.
Thank you, Your Honor.
You may be excused.